All right, before we begin in this matter, there's one procedural issue that I think we need to take up. In reviewing the record, it appears that the State of Tennessee Department of Children's Services would be more properly designated and aligned as an appellant in this case rather than an appellee. And so we are going to enter an order for the record that realigns the State of Tennessee Department of Children's Services as an appellant, because the department is requesting reversal of the trial court's order. And that will have, then we will have two appellants in the record. We will have the biological mother, Mrs. Robinson, and the Department of Children's Services, and then that will leave Ms. Hamilton as the appellee in this matter. In doing that, we have two appellants designated now, and have counsel for the two appellants as designated currently discussed how you wish to split time in this matter?
Yes, Your Honor, we have.
All right. And what will that be?
I will be taking 11 minutes for my argument as the appellant. Ms. Adams will be taking 2 minutes for her argument, and will be reserving 2 minutes for rebuttal.
All right. All right. Any questions then about that procedure before we begin?
No, Your Honor.
All right. Appellant may proceed.
Good morning, Your Honors. I am Laura English of the Shelby County Bar, and I represent the mother, the apparent appellant, Taranay Robinson, before the court today. I would like to reserve 2 minutes for rebuttal.
All right.
May it please the court. We are here today because a court has been asked to take one of the most drastic actions that our law permits, terminating the rights of a parent to a child. A parent's right to raise their child is one of the oldest and most protected fundamental liberty interests that are afforded an individual under both the federal and state constitutions. While this right is not absolute and may be challenged, to do so, to challenge and sever a parent's right to their child forever, the law requires that a finding of clear and convincing evidence must be made for two prongs. First, that there is a statutory ground for termination that exists, and that if that ground exists, the termination is in the best interest of the child. Mother would submit to this court that neither of these prongs was met by the trial court in this matter. In the lengthy opinion issued by the trial court, the court only found one statutory ground of termination had been met by the petitioner by clear and convincing evidence: that mother committed severe abuse against the minor child. For two reasons, this finding and conclusion is incorrect. First, mother submits that Ms. Stringfellow, the petitioner in this matter, is barred from raising the issue of severe abuse as a statutory ground for termination because of the doctrine of res judicata. The Juvenile Court of Shelby County, Tennessee held a full adjudicatory and dispositional hearing on the department's petition for dependency and neglect and issued a ruling that found the perpetrator of the severe abuse was unknown. This court has held in Ray Heaven LF that the doctrine of res judicata bars a parent who has been found to have committed severe abuse from again relitigating that issue in a termination of parental rights. It is our position that the doctrine of res judicata would apply equally here.
Was Ms. Stringfellow, which I believe I referred to earlier as Ms. Hamilton, but one and the same, was she a party to that severe abuse hearing?
She was not a named party. However, the doctrine of res judicata says they may be parties and or privies to the action. She was a privy. She was a foster parent contracted by the Department of Children's Services. She was present and had the right to be present at every hearing. She was contracted to be a foster parent. She had the right to be present, and she was present. And so, Your Honor, under the doctrine of res judicata, if a foster parent files for termination and relies on a finding of severe abuse that a court makes, they're still not a party. It has to apply both ways.
Thank you.
The elements of res judicata require, first, that a court with competent jurisdiction rendered an underlying final judgment. There is no dispute that the Shelby County Juvenile Court is a court of competent jurisdiction. It is the court that has original and exclusive jurisdiction over dependency and neglect proceedings. There also is no question that the order that was entered was a final judgment. It was a final judgment from which an appeal could have been taken, and that language was contained in the order. Ms. Stringfellow relies first on the fact that alleging that she was not a party to the proceedings. As I've already stated, a foster parent who files for termination can rely on the doctrine of res judicata when a court finds a parent committed severe abuse, even though they are not a named party in the dependency and neglect proceedings. Therefore, it has to apply the same way in this case.
Did the juvenile court find that mother did not commit severe abuse?
The juvenile court found that the evidence was insufficient to name a perpetrator.
Thank you.
Finally, Ms. Stringfellow argues that the doctrine of res judicata cannot apply because the juvenile court found the perpetrator was unknown, that it did not fully litigate that issue and issue a ruling on its merits. Again, mother would submit this is simply incorrect. The juvenile court had a full evidentiary hearing. The juvenile court had far more information than the trial court in this matter. It had the deposition of the expert that the state took, the medical expert. It had medical records. It had testimony from the parties. It had testimonies from the department. It had, full exhibits and witnesses about what occurred in this case. Very little of that was actually presented to the trial court. And with all of that information, the juvenile court still found that the evidence presented was insufficient to identify the perpetrator of the severe abuse. It did find the child was a victim of severe abuse, but said the perpetrator was unknown.
I have a question. I don't know how it plays into this, but do you know why sua sponte, the juvenile court suddenly entered an amended order? It's drastically different, in my opinion, or substantially different than the original order regarding the mother's.
Your Honor, this was addressed briefly at the trial when we were arguing the issue of res judicata. And the attorney for the Department of Children's Services, Mr. Kirk Stewart, who was present, was actually the only attorney who was involved in the dependency and neglect proceedings in juvenile court. And his information to the court was that it issued a sua sponte order when the court realized that the original order incorrectly named mother as the perpetrator of the abuse, and that was not consistent with the court's findings at trial. So this court amended the order to correct the order so it correctly reflected the court's findings at the original trial.
Did the amended order state that that was the court's reason for its entry?
It did not, Your Honor, not with specificity. But that was the only thing that was changed in the order. The order continued to make the same findings, that the child was a victim of severe abuse, that the petition for dependency and neglect had been sustained by clear and convincing evidence, the child was dependent and neglected, the child was a victim of severe abuse, but it specifically amended the finding as to who the perpetrator of the severe abuse was to correct it to show that it was unknown.
But did not state in the order its reasoning for doing so.
Correct, Your Honor.
So the DCS attorney was giving what he believed to be the reasoning as he believed it.
He was the attorney who was asked to redraft the order by the court.
Was there any subsequent hearing or anything that led between the time of the first order and the amended order? Was there a subsequent hearing where additional evidence was presented, or was it just the order and then there comes an amended order out?
There was a ratification hearing for a permanency plan, Your Honor, that occurred in between the issuance of the first order and then the sua sponte amended order. That's the
No
only...
further proceedings on the petition for dependency and neglect and severe abuse, though?
No further proceedings on the
All right,
petition for
thank you.
dependency and neglect. Because Ms. Stringfellow is barred from raising the issue of severe abuse, that is the only statutory ground that the court found existed for termination of parental rights. Without that ground being available to her because of res judicata, then she has no grounds, as all other grounds were denied as being met by the burden of proof of clear and convincing evidence. If the court were to find that she is not barred by the doctrine of res judicata and looked at a new finding that mother committed the severe abuse, which is what the trial court did here, they did not consider the issue of res judicata, but found based on its own merits that mother committed severe abuse, we still argue that the court made an improper ruling because the evidence did not support a finding of clear and convincing evidence that mother committed the abuse. The court found that mother had committed severe abuse not by being the actor of the severe abuse, because she knowingly failed to protect the child. To knowingly fail to protect is a very specific definition that this court has spent a great deal of time explaining and expounding upon. But essentially, it comes down to looking at the weight of the factors and the individual facts as a whole, whether a parent knew or should have known that the child was at risk of serious bodily injury or harm, and took deliberate ignorance and recklessness by ignoring the facts that presented that child in harm. That is not what happened here. It is important first for the court to understand that at the trial in the termination of parental rights, not a single medical record was introduced. Not a single CARES report from Le Bonheur was introduced. The only proof that was introduced by Ms. Stringfellow was the testimony of one DCS worker who testified that the department substantiated mother as the perpetrator of severe abuse based on a single text message in which she simply just didn't deny doing it. That was the basis of their substantiation. I submit to this court all of the evidence that was presented at the termination was available to the juvenile court at the time of the original adjudication. The juvenile court still found you could not find the identity of the perpetrator. The juvenile court had the substantiation by the department, which is only an administrative substantiation. It is not a legal conclusion. There is no evidence that mother knew or should have known or deliberately ignored facts that would lead her to believe that this child was in danger from anyone. Mother sought medical attention multiple times. There were multiple individuals around this child. Mother was 17 years old. Yes, she was a victim of domestic violence perpetrated by the father, but there was no evidence that father had ever exhibited any violence toward this child or any other child. Yes, father had pending criminal charges, but there was no evidence as to what those criminal charges were. Were they traffic tickets? Was it a violation of probation for some other? Was it drugs? We don't know. There was no proof. No proof entered to show why mother should have known that this child was at risk of danger. My time's up. Thank you.
Thank you.
Good morning. May it please the court, Catherine Adams with the Tennessee Attorney General's Office for the appellee, or now appellant, I guess, the Department of Children's Services. It is the department's position that termination of mother's rights is not in Elijah's best interest. And I think one of the clearest ways from DCS's perspective to think about this case is to compare it to the case of Gabriella D. In In re Gabriella D, the children were removed from that mother's custody due to her severe neglect of the youngest child, which was later adjudicated to be severe child abuse. After the children's removal, that mother significantly changed her circumstances. She removed herself from an unhealthy relationship with the children's father, she stopped abusing drugs, completed all of her permanency plan requirements, and she established a safe and stable home. At the time of trial, the children had been on a trial home visit with the mother for 2 years with no incidents, as she was providing safe and stable care for them. The Supreme Court determined that though Factor 6, the severe abuse factor for the old factors, pre-amendment factors, did weigh in favor of termination in that case, the Supreme Court determined that was not outcome determinative, and that the majority of the other factors weighed against termination. And here, the circumstances are very similar. While Elijah was removed for the severe injuries he suffered as an infant, since that time, mother has significantly changed her circumstances. She has separated herself from father, completed her permanency plan responsibilities, and has established a safe and stable home. None of her other 3 children have ever been removed from her custody, for injuries or for otherwise. And at the time of trial, she had engaged in incident-free parenting of Elijah for 5 years through 3 weekends per month of unsupervised visitation that the DCS had no concerns of. The conclusion here should then be the same as in Gabriella D., that the best interests weigh against termination. I can answer any questions the court may have.
I see none. Thank you.
Thank you so much.
We'll hear from the appellee.
Good morning, Your Honors.
Good morning.
I'm Kevin Weaver from the Memphis Bar, and it's a privilege always to be before this panel. I represent Hannah Hamilton, who now is Stringfellow. She was married after these proceedings began, so it can be a little confusing if you might see different names. But, Your Honor, as you're well aware from the record, these proceedings have been going on for quite some time, unfortunately. But this child initially came into the care of my client, Elijah, came into the care of my client back in 2017, 3.5 months old. We, in our brief, we have obviously agree with the trial court as far as the finding of severe abuse and as far as the finding that there was best interest arguments to terminate. We also raised the issue that the court ruled against us on the support issue. And I'd like to address that first because that is something we raised on our reply. We had argued in our brief, in our pleadings, that there's a grounds for termination based upon token support for this child in the 4-month period prior to us filing our petition. That determinative period was like, we filed in July, so it was like March to July, so there's this 4-month period. The court ruled that there was sufficient support during that time for this child. Our argument is that there was not. We believe we showed that during that time period, we requested, asked from the department and asked from the mother to know what she provided support. During that time, she was seeing the child every Sunday for 3 hours for most of that time period. And then right at the end, she had some weekend visits that started. We asked through discovery to understand what she had provided during that time. Nothing was produced. No list of items, no list of cost, nothing. All that was in the record was testimony from the social worker and from the mother that there had been some clothes given and a few things like that. And actually, when you look at the details of that testimony, during that time period, the mother just testified that she had given, I think, a riding toy and a few small items. The burden is upon my client to show that the issue about the means to support, in other words, what means did the mother have to provide support? The testimony shows and the evidence shows that the mother was working at that time, making roughly $600 a month. She was receiving benefits of state benefits of roughly $300, close to $1,000 worth of income. Her expenses, she was living with her aunt, no rent. And there's just, we have no documentation of anything being given to that child during that time, except my client did state that there were a few times that she noticed the child had some clothes differently than what she had provided when she went to visitation. Appellant argues that somehow we have the burden to show what the value of all that was, but when you're stonewalled and you can't, that they don't provide, not only did the mother not provide the information, but the department who's overseeing all of these visits and who puts in their permanency plans that she is providing in-kind help for this child could produce nothing. And so there's nothing in the record that other than token support. So we believe that that ground exists. that during that time period, because we don't want to get confused, there's a lot of time in this case, but for that issue, it's for that 4-month period. And so we believe that we do carry the weight of showing that was simply token support. I'll move on to talk about the issue of the severe child abuse. There were some questions raised. I'd like to try to address the questions from our perspective of some of these questions that were raised about the severe abuse and the res judicata. One of the questions was, was this res judicata in the sense that my client was not a party to that case? She is a foster parent, but she's not privy. The statute, when you look at the statute on the Bill of Rights of the foster parent, when it comes to dependency neglect, at the time that this case was going on, very limited in what they can do, what they can say, what they can appear at. That has been revised over the last few years to make it more available for a foster parent to be involved, but certainly not a privy to this case. Can't file pleadings, didn't have representation during that time, could participate in the hearings, but many times in those situations with the Zoom, like she wasn't even in the Zoom hearing. She was just like in the waiting room and didn't hear testimony and that sort of thing. So, but backing up on the res judicata, our position is that defense was waived from the beginning because it never was pled as an affirmative defense. At the time of trial, the court initially, and in the record it shows that he was going to address that issue after he heard the proof. And so he went ahead and heard proof, had us put on all the proof that we would have to put on, and we put our proof on about the severe abuse. And then on the back end is when he ruled that defense was waived, and we believe it was waived because it was never, nothing was ever amended. There was an argument that it was tried by implied consent, but under when you look at the record, the way that the proceedings went, the court put that question in abeyance and had us go ahead and put proof on. And so we did. And as to this issue, the fundamental issue, I think, on this whole thing with severe abuse, the court has hit upon this, is this finding, this perplexing amended order that was entered, where you had initially a finding that both the mother and the father had abused the child. And then sua sponte, no hearing, no anything, there was this amended order that all of a sudden it became unknown about who the perpetrator was. Our position is that even under the res judicata argument, even if you have that argument to make, that issue was not resolved. It was, yes, there was litigation, there's no question there was severe abuse. One of the reasons that medical records and things weren't introduced at the trial level is you had these clear findings and even testimony from the mother and from others that these injuries occurred. There was, severe injuries to the leg, multiple fractures. And so there was not a question about the injuries. It became, how did that happen? It's clear from the testimony, it's clear from the record that primarily this child was either with the mother or the mother and the father. The mother was almost 17 at that time. She was living with her mother. Yes, she did bring this child to the hospital when she noticed some injuries. The question in this is what did she know? What did she know about this father that would indicate that he could be the perpetrator? She knew a lot. She testified to the fact that while they were together, but even before she got pregnant, this man beat her with a belt, choked her, put a gun to her head. They had multiple times of domestic violence with each other, and that even continued after this child came into the care of the department. And so and this fella, she knew he was a member of a gang. Her testimony was that she was involved in some of that too. So there's a lot of information there about his violent tendencies. To say that she didn't know that he would hurt a child, I think is stretching it greatly, because the issue is, was he prone to be violent and to be able to do something like this? And she was on notice the first time that she went to the hospital that this child had injuries that were not injuries that normally would happen to a child, a broken femur and fractured in many ways. And this is a child that's 3.5 weeks old at that time, maybe 3 months old at that time. And so we think the knowledge was there, and that she either ignored it or chose not to deal with it, and she did not keep this fella from her child. The child would stay with the father without her, or with her.
Question, if I may, Counselor. I know there were maybe 3 visits to the hospital. She did take the child, and they found a break on one. And then later on, there were 5 more breaks. And it's not clear to me, in what I've looked at, as to whether this child left knowing those injuries had occurred, and then more injuries, more breaks occurred, or did they just miss those the first time? Do you know from the record?
Well,
Would she have taken the child back to that environment where it occurred?
Yeah.
And then later?
that they were additional injuries.
Based on your opinion, what you saw and heard,
Right.
they occurred after
Right.
that first visit?
They were,
Not
they
just
were
missed
on, they were on, yeah, right. They were additional, because, and so all of this is happening to this child, and they're the 2 primary people that are there. And so this idea that this is an unknown perpetrator, and I'll circle back around to that question, is like, since there was the determination of unknown perpetrator, and appellant has pointed this out, we have pointed this out, the cases that they refer to, that this is res judicata, both of those were situations where there had been a finding of severe abuse or not severe abuse as to that particular parent, okay? Our situation is different. We have unknown. Our position is that in all due respect to the juvenile court, they sort of punted this issue. And I think that's one of the reasons that you have in the statute, the TCA statute, when you look under 36-1-113, it has a specific provision in there that says, under the grounds, that when it comes to severe child abuse, and it doesn't say it anywhere else in the statute, but here, that the trial court of the termination issues can take up the severe child abuse issue and can try that separately from if there was no finding or if there was never any discussion about it in the dependency neglect, because this happens. This isn't the first case I've seen where you've had an unknown perpetrator. And so, and as the court, I think, rightly pointed out, it was that issue was not resolved and was not dealt with. We thought it was because there was a finding that both were guilty of severe abuse, and then we have this no further hearings, no further evidence, no further motions, this order that comes out later that it's unknown. And so, and we believe that our record shows for clearly that the mother had knowledge to know that there was a propensity for, especially the father, to violence and could be violent. And then when she sees these injuries and still allowing the father to be, yes, sir?
Don't you have 2 options, not only knowingly, but gross negligence?
Yes.
So you're
Yes,
not stuck with just knowingly?
No, it's
also
knowingly that falls under that category. It's sort of like an act of omission or commission. You can choose to ignore and be it almost a gross negligence, or you can choose to just not deal with it in other ways. But you're right, Your Honor, that's true. And that falls under that category of how you do that. Real quickly, I've got less than a minute. I'd like to address the best interest arguments. Our position on that, it's clear from our brief, that the difference in this Gabriella case, real quick, that was cited, significant differences. The mother on that case had 3 children that went into care. She had already had those children in her care. One was 4.5, and I think the other one was 2.5, and the other one was 6 months. They had been in her care for a while before they ever came in. So she had a bond with these children before they ever came into the care. Then, once they came into care, it was a little over a year before they were back into her care. The time frame was very short, significantly different than what we have. We have a situation where this child was over 3 years old when we brought our petition, and there were still just weekend visits going on. I mean, we have all these permanency plans, but she wasn't completing the permanency plans. I mean, she had to turn 18, but even after that, it was 2 years after that.
Thank you, Mr. Weaver. You've used your time.
Thank you.
We'll hear from the appellant in rebuttal.
Thank you, Your Honor. I want to use my time wisely, so I'm going to very quickly address our position on the grounds of abandonment for failure to pay child support. A permanency plan was ratified by the juvenile court squarely within the time period on April 6, 2020, that found mother substantially compliant with all of her tasks, including the duty of support for this minor child. That order was not challenged. That plan was not challenged. It was ratified. That is a valid order of this court. And in every subsequent permanent parenting plan that was issued over the next 7 years, or 5 years, excuse me, mother has been compliant. It's never been challenged. The duty to support has been met. There's a finding from a competent court that says so, and that's our position. As to the issue of the waiver of res judicata, Your Honor, we argued this by implied consent. Tennessee Rule Civil Procedure 15.02 says that when a position that is not pled in the pleadings is argued by implied consent, the court shall consider it as if pled. There is no question that we argued this at the trial. It was never argued that we waived by the petitioner. We argued it at trial. We did not waive that defense because we tried it by implied consent. I want to spend the rest of my time talking about best interest because this is a policy. This is not just specific to this case. This is not a situation where mother took 5 years to get it together. The juvenile court granted her unsupervised visitation leading up to a trial home visit. That is the final step in returning a child to a parent. Before this petition was filed, mother had done everything. She was fully compliant and she was ready to take custody of this child. And it was not until she was given unsupervised first, third, and fifth weekend visitation that Ms. Stringfellow then filed her petition. This case has been pending for 5 years. This is 5 years that mother has been parenting this child every other weekend. That's standard parenting. Thank you.
Thank you. Thank you both for your arguments. We will take this matter under advisement, and we'll get you a written opinion as soon as possible. You may be excused.